we've got lots of panelists, and we got our speakers, and so I think we're going to start now. I'm Doran Doeh. I am one of the co-moderators. I used to be the head of the Denton's office in Moscow. I'm now semi-retired, acting as an arbitrator based in London. Delighted to join this session on oil and gas disputes. And I have two co-moderators, Paul Griffin, who has had an illustrious career. He's a well-known expert in international matters of gas and LNG. He started his career at, oddly enough, we've had reverse careers. He started with what was then Denton Hall, and then moved to Herbert Smith, and then moved to Allen & Overy, and he's now at White & Case in a semi-post-retirement career, but he's still very, very busy giving expert evidence that he was telling me about before we started. And the other co-moderator is Mark Beeley, who started at Herbert Smith and then moved to Vincent & Elkins for many years, and is now with Orrick. And he's a dispute specialist in oil and gas disputes. So we've got a very interesting panel. We'll start. I'm going to speak on the legal status of the Caspian, largely because it's a subject I happen to know something about, and I hope it's of interest to people. Most people know something about it, but not all that much. And it is important because there's so much oil and gas under it. It's the most useful way of looking at it, I think, is to take a historical perspective. Before the breakup of the Soviet Union in 1991, there were only two countries on the Caspian, the USSR and Iran. The big question is whether it's a sea or a lake. From a legal point of view, it's called a sea. It's the Caspian Sea. It's big, and it's salty. So people say, well, you know, it seems like a sea to me. Why isn't it a sea? And the answer is that it's wholly enclosed. It doesn't communicate with any other major body of water. I think there's some kind of other one that it connects to, which is also wholly surrounded by land. And this became important when the Soviet Union broke up and there were suddenly four new littoral states. It's worth bearing in mind that the interest in offshore interests, or the interest in offshore developments, and particularly in oil and gas, only started to develop after 1945, when Harry Truman declared that the United States was interested in developing its offshore assets, particularly in the Gulf of Mexico, and a lot of other countries joined in after that. So the old 1921 and 1940 treaties that there were between Russia and Iran were mainly about fishing and navigation. Nobody thought of exploiting the seabed in the way we do now. There was a body of customary international law that grew up very quickly after the Truman Declaration. There was a Geneva Convention of 1982 that declared certain principles. These were built up on the basis of decisions of the International Court of Justice. So those are really the key features that have built up this body of international law. The Geneva Convention sort of codified what everybody regarded as customary international law. But the most important thing after that was the United Nations Convention on the Law of the Sea of 1982, which is usually abbreviated, pronounced UNCLOS. And that extended it further and further solemnized the conventional law. The catch is that Iran and Turkmenistan are not parties to it, probably on the basis that it wasn't relevant to them, but they didn't join. It's also interesting that Turkey didn't join, which is of relevance in their dispute Greece now. But the ICJ decisions essentially, and conventional, the customary international law basically establishes the equidistant special circumstances rule, which provides that essentially if nations face each other on the other side of a body of water or they're adjacent, you would either extend the line of the land from the adjacent parties, or you would draw a median line between the two facing each other, subject to special exceptions, like promontories or islands. And one of the big issues, for example, between Greece and Turkey is all these huge numbers of Greek islands right up by the Turkish coast, that makes Turkey even less inclined than it might otherwise be to accept principles of customary international law. So what happened with the Caspian? Nobody with bodies of water that aren't subject to customary international law, it's not clear what happens. And there were all kinds of discussions. There was a suggestion that the jurisdiction should be exercised jointly. They should have 20% each, or that Iran should have 50%. Now, Iran is in a very sensitive position, because if you look at the way the lines work, if you extrude the border lines for Iran, they come out very flat in the Caspian. And if you extended them, they'd only get about 15%. So 20% was going to be a big improvement for them, but they still never accepted it. And there were all kinds of discussions between the countries. In the northern part, Russia, Azerbaijan, and Kazakhstan agreed bilateral treaties between themselves, and they all got on with development. The difficulties were in the center of the Caspian between Azerbaijan and Iran and Turkmenistan. There are quite a lot of environmental sensitivities relating to the ecology and biodiversity. The sturgeon is one of the factors, because sturgeon is something, you know, with all the caviar that only really inhabits the Caspian Sea, apart from a few farms in other parts of the world. But that's sensitive, and apparently the seabed is very sensitive. And the Russians tended to object to whatever anybody else wanted to do, as did Iran, because they were the two most sensitive. On the other hand, in the northern part, as I say, Russia mostly agreed with the others. And in the end, they came up with this convention on the legal status of the Caspian Sea in 2018, which everybody signed, and it provided special legal status. So it's no longer a question of whether it's a sea or a lake. It has special legal status. It sets up fishing and navigation, and it provides, most importantly from our point of view, that each of the coastal states has rights over its share of the seabed and subsoil, and that legitimizes the existing bilateral treaties and provides for more designations. It provides the delimitation of sectors left to bilateral. It should be left to bilateral, multilateral agreements, having regard, and this is an important phrase, to generally accepted principles and norms of international law. So that effectively adopts customary international law to disputes. It provides, again, very importantly, that coastal states have the right to lay submarine cables and pipelines on routes to be determined by agreement. So it means that Turkmenistan and Azerbaijan, for example, could agree a route of a pipeline, but it then goes on, provided the project complies with environmental standards. So there's still room for people to object on the basis of the way it upsets the seabed. Most significantly, there is no real mechanism for determination of disputes. It provides for consultations and negotiations, and provides that if they fail, disputes should be resolved through other peaceful means provided for by international law, but it doesn't actually compel anybody to go to arbitration. And there is no prescription or provision for ISDS, so investors are not provided for. The only country that hasn't ratified so far is Iran, and it's not clear what's been holding it up. There was an incident where the son of the Shah, the Reza Shah Pahlavi, said that he thought it was disgraceful what Iran had agreed, and they should fight for their rights. And he was going to instigate it, but I don't know what status he has in Iran, and nothing much has happened. So that's basically where it is. It's a very interesting from an intellectual point of view, but I think on the whole it means that people get on with it in the areas that they've agreed. It remains to be seen whether we'll see further development in the southern areas, and there may be some resulting from this, but that would probably need Iran's ratification. Anyway, that's enough from me. We'll turn over to Paul, and then once we're all finished, we very much invite people to contribute or ask questions or whatever they want to do. Paul, over to you.
Doran, thank you, and thank you for the introduction and that exposition in relation to the Caspian Sea. And welcome to all of those who've made time to join in. Thank you. Doran has asked me to make some comments on international dispute resolution and the gas and LNG business. And I think for many, gas now sees itself in the sunlit uplands. This is the time for natural gas. It's been the Cinderella to oil for all its life. Now is its time. Investment decisions have been made many over the last few years. It's perceived to be the cleanest of the fossil fuels and a bridge to a low carbon future. And this is whether it's as pipeline gas or as LNG. There's an availability of funding, diverse sources of funding, so money is not the issue. And also there's an increasing participation in the LNG business, new people coming into it, trading businesses, aggregators, and an integration of the diverse markets. And certainly Russia and the former Soviet Union have been very significant in this, but previously separate markets of the Americas, Europe, Middle East, Africa, and Asia Pacific, particularly North Asia, coming together. But there are gathering clouds, and for much of the world, the future is the electron and not the hydrocarbon. And there may be a role for gas as the bridge to a low carbon future, but for some people, this may well be a short bridge. And whether you look at the blurring of methane with hydrogen, one of the issues which has become very significant is that for these long-term contracts which have underpinned the gas and LNG business, there is now a change of circumstances which is coming through, which really is the way in which gas is measured for the purposes of emissions and carbon content. And when you measure the chain, yes, at the point of burning, gas is the cleanest of the fossil fuels. And indeed, pipeline gas probably has a benefit here. But if you look at LNG and the usage of gas in order to move from the point of production in a distant state and then vessel through to the point of consumption, those measurements would show you that natural gas is probably dirtier than oil. So gathering clouds in relation to gas, exporting countries taking different views in relation to environmental requirements from those of importing countries. There are certainly a number of consultants who would point to oversupply, COVID effects of consumption markets, and indeed geopolitics. You only have to look at what happened in the summer in relation to the United States, China, and Saudi Arabia to see the effect there. So what's this doing to the contracts for LNG and gas? Well, one is that they are moving to shorter durations. those people who are involved in this business are looking to limit their risk by moving to shorter contract durations, but they're still very long term. They may not be 25 or 30 years anymore, but even at 10 or 12 years, certainly for most lawyers, these are extremely long-term contracts. The parties are seeking flexibility everywhere. Flexibility, flexibility. Portfolio arrangements are beginning to prevail. So companies like Shell or BP or Total, and even trading businesses, Gunvor, Trafigura, Vitol, portfolio arrangements, it's not about producing in one point and selling in another. This has become a market. And with this, seeking flexibility, uncertainty, lots of provisions for meeting and discussing when circumstances changing, exercising good faith, obligations of good faith, dilution of obligations. So as rather than firm obligations, instead reasonable endeavors obligations. So the commercial effects of certainly price risk, which is well known in the price reopener arbitrations, but also now looking at other changes of circumstances. And these can well be fiscal, regulatory, as well as legal. So with changing circumstances, what happens to your contract? And the likelihood is, if you're in the international LNG business and often in the gas pipeline business, your governing law will be a common law, and it will often be English law. And those laws will look to enforce the bargain the parties have made. And part of that freedom of contract, there isn't a code that's hanging over you. Part of that freedom is that if you wish to provide reliefs if you're in trouble, or if you wish to provide for termination if you're in trouble, then you have every right to do so. But if you don't, then the arbitrators, or for those rare agreements which will go to courts, judges are not going to make those for you. These contracts are exercises in clairvoyance and what is known as presentation. This legal principle of bringing future events into your present contract. You're making a contract for 20 years, you look forward, what if this happens? What if that happens? Put some words in, get the lawyers to put those in. That's what you're trying to do. And the contract sets out the rule of the parties. Price reopeners have been a staple diet for many arbitration practitioners over probably the last 10 years or so as Europe undid those contracts. But the nature of the business risk is likely to be beyond clairvoyance. And certainly it's a very rare contract which exists now and which has predicted decarbonisation to the extent that it's now happening. And for example, vessels of LNG now being sold on a green basis. Shell is leading the way with this. So contracts are still being made. If you look at certainly in Russia with the new projects, contracts out to 2040 or so. Well, by 2040, the world has gone to zero carbon in the eyes of many people. But your contracts don't reflect that. So at a time of divergent interests, just rushing through, what do? Do you look at your text to see that you have some words to help you, or do you look at the context of your relationship? And for many, it's a matter of enforcing the bargain that you've made. But if something happens where it was never in the contemplation of the parties, well, where does that take you to? Sometimes you'll find a hardship clause from the French model. Sometimes a force majeure clause, which will give a relief at a time of breach. And sometimes you'll be required to take account of the interests of the other party. And under English law, relational agreements are under some concentration as making moves to a treatment which is not the traditional one. So when it comes to resolving the dispute, keep your eyes wide open before marriage, half shut afterwards. Wonderful expression, and certainly most people would apply it to marriage, but actually it works pretty well in long-term relational contracts too. All that time in the courting phase, but once you make a contract, you are tied in and you're unlikely to escape. But when these changes of circumstances happen, is it really a dispute? Is it something that your traditional arbitrator or judge would say, a breach, an assessment of damage, an award, a payment? And it's not really. In these contracts, it's often a matter of remaking the deal, resetting the commerce, which has taken the parties from year 1 to year 7 and needs to take them from year 7 to year 20. So arbitration, Asia is showing now a move to arbitration and also a move to expert determination, different process there. And for me, it's probably only a matter of time before a more relevant, more appropriate means of resolving this resetting of the commercial bargain begins to take over. Certainly within decarbonisation, and it's the case within prices as well, often global aims but local implementation, not easy to deal with. Regulatory and fiscal effects, and although gas is the cleanest of the fossil fuels, it's still a fossil fuel and is in the target. A bridge to a low carbon future? Maybe so. But what I would leave you with today is a thought that it's probably timely to revisit the ways of resolving differences under these long-term relational agreements. And many, obviously stereotypes, but many Asian companies will approach their contract by reference first to their relationship rather than to the words of their contract. Many Anglo-Saxon companies will do the opposite. But price disputes have been the catalyst. For me, there's every likelihood that decarbonisation will take that forward. And rather than a periodic testing of the fittest in an adversarial process, what about relational resolution? Because as Indira Gandhi said, you can't shake hands with a clenched fist. Thank you. And I think, sorry, Doran, I thought maybe it falls to me to move it on to Mark, but I interrupted.
On to Mark, indeed. We can't hear you, Mark. You need to do something.
The famous phrase of 2020 being "you're on mute." But, with it, hopefully recovering from that false start, I wanted to both thank Paul and Doran for their remarks and say good afternoon to everyone who's participating today. It's a pleasure to be with you. What I wanted to do in this 5 minutes or so was to try and widen the scope of our discussion. Doran has spoken to you about a very interesting state-state framework of an oil and gas dispute involving the boundaries around a geographic center with a huge degree of hydrocarbon reserves. Paul has spoken about a midstream or downstream particular issue about LNG disputes, but I wanted to talk slightly more broadly about the sorts of oil and gas disputes you might see in the CIS region. How those are resolved and what sorts of issues you should be aware of, and what makes oil and gas arbitration, particularly in the CIS, different than what you might hear at any conference you go to about disputes or arbitration. I suppose the starting place is that there are a lot of disputes across the oil and gas industry, and that's for very obvious reasons. Almost everything involved in this industry is high value. It's normally, as Paul says, very long term. These are the sorts of disputes which people have money to fund and which the sums involved are so significant that normally they can't just be let go, and so these matters need to be escalated. But particularly in the CIS region, I think we see an additional driver for disputes, particularly in the upstream space. Coming out of the relative newness of these contracts in the region for the obvious historical reasons. You have a large number of initial upstream investors who, although there were some of the majors who moved in the early stages, there were a lot of smaller players who were the ones willing to run what was perceived to be a unusual degree of country risk, as countries were being born and licenses were being offered for the first time. A number of investors rushed in, some of whom proved to be very profitable partners for states, but many of whom turned out not to have the resources they claimed to have or the ability to operate in the manner they said they could. At the same time, you have oil and gas ministries, newly formed, often with a lot of institutional experience, but coming to matters new under new oil and gas laws for countries, experiencing for the first time what to do when a contracting party fails to come up to standard, or if a better deal comes along, considering how that can be reworked. There's obviously the more recent impact of sanctions, which have bitten strongly on oil and gas operations. How do certain projects continue to be funded? How do they continue to operate? How do they export in the new regimes we're facing? And there's also the strong concept in the region of the operating entity. In many production sharing type arrangements, there's often an operator, an individual sponsored by the consortium of contractors who takes the lead. More unusually, in both CIS as in China, we tend to see that as a incorporated venture. So rather than just being an unofficial agreement as to how matters will be progressed and who does what, there's a company appointed as the agent of the parties, and that tends to bring forward additional disputes around issues such as shareholder control, abuse of minority interests, which you don't necessarily see outside the region in the same way. So lots of disputes on the gas sector, lots of particular factors in the CIS. Most of these get resolved, as Paul and Doran said, by way of arbitration. And in that regard, there is a huge export from the region to the arbitration centres of the world. The Stockholm Chamber of Commerce continues to see an extraordinary number of disputes from the CIS region. Taking just Russia alone, it is the second largest constituent of users for the SCC statistics in 2019. Similarly, the London Court of International Arbitration, 10% of its disputes for 2019 came out of the CIS region, and the ICC similarly follows. So these disputes are taking up a lot of the main arbitration hearing centres' time, and we're now seeing the advent of popular dispute resolution centres within the region, the Astana International Arbitration Centre being a great recent example of a free zone being set up with a very strong play to try and capture regional disputes which are currently being heard in London or in Stockholm. So it's a very exciting and mobile time of these disputes. There's a lot of them. They're being heard in multiple places. And they break into a number of categories, in addition to the ones we've already talked about. I'm going to propose, for purposes of this discussion at least, 4 broad categories. We tend to see state-state disputes, potentially the sort Doran mentions about access to land and border disputes, or supply of energy and energy security issues, some of which may be resolved by way of the International Court of Justice, and others may go to arbitration, the Permanent Court of Arbitration, or other venues. We see extensive numbers of disputes between states and investors. And certainly I've been personally involved in recent disputes between investors and the state in Uzbekistan. There's plentiful examples of disputes in Kazakhstan, and some very well-known ones with the Russian state, where there's a dispute arising out of a production sharing contract or the license or the equivalent between the state on one side, who's saying often, where's all the oil and gas you promised me? And the contractor saying, well, hang on, you promised me an exclusive license for 20 years and someone else has just got 10% of my license acreage. Often those disputes for the states then morph into disputes between the consortia parties. Because of the huge sums involved in oil and gas operations, it's very rare for us to see simply one contracting entity. Normally there are 2 or 3. And they do a very good job often of presenting a united face when they're dealing with the government, complaining about the horrible way they say they've been treated. But as soon as that arbitration reaches its end, the contracting parties will often turn around and say, well, if only you hadn't done that, we'd have got a better result. Or the like. And frequently we see disputes either arising out of that or one party failing to pay. Again, a significant issue in the region where people have overcommitted to the finances they can bring to the table, or have been optimistic in where they think those finances will come from. And so there are often disputes even within consortia as to who's paying the money for what. And then there's third-party disputes, so particularly in the oilfield services area or gas field services area, as I should probably now say, given as Paul says, gas is having its day in the sunshine. But these are disputes between the licensing parties and oilfield services providers, so the drilling rig contractors, the providers of labour and access, the catering companies who make sure that the people working in the oil field are receiving their meal breaks. All of these are ripe areas for dispute, and particularly given the COVID times we're moving for and the effect on the economies, we're seeing a huge number of these sorts of more smaller disputes where operators or of rigs or owners of rigs or services are claiming insolvency protections, and what does that do to people who are just about to launch on a 21 well campaign to discover that their rig contractor has just announced that they're in Chapter 11 protection in the US. And while you're getting wonderful noises about how the contractor is going to still perform those contracts, at the same time, you know you have no effective right to sue them if something goes wrong. And that may well weigh on your minds if you're considering the risks of environmental spills, etc. I'll just close by giving one real-life example of how one issue can spawn all sorts of disputes in all these areas, and arising out of an issue which happened in Kazakhstan, in a very well-known project, but one where there was a offshore development with an offtake pipe which, when it came to be filled with hydrocarbons, had the wonderful feature of it leaking on a fairly regular basis. And it turned out that about 75% of the welds had small failures on. So big issue there. Offtake pipeline, which ran some 80 miles and had been buried under the sea, wasn't functioning the way it should. What disputes arose? Well, first of all, the contractor had to vent the pipe to get it fixed. And so there was a huge contamination problem. So the government turned around and instituted pollution fines. And there was disputes about those fines, both under the production sharing contracts, but also under an investment treaty, the Energy Charter Treaty. So that had both a contractual element, but also an international treaty element. Beyond that, the consortium all turned around and pointed fingers at each other, particularly against the operator, who they all said, well, why didn't the operator do a better job of making sure that the contractor didn't make this deficient pipeline? And then obviously, of course, the operator turned round to the contractor and said, well, we've got a claim under our EPC contract for the fact you couldn't do this work correctly. So one issue spawned 7 or 8 different disputes, none of which were small, none of which were easy to resolve. But that's just a good illustration as to how any of these disputes are multifaceted, they're high value, and they're very important for all the participants. And so I think we are very lucky to be speaking with you about this topic this afternoon, because there's certainly a lot of interest in it.
Indeed, I'm pleased to say that we have, in addition to the 3 co-moderators, we have 36 people in attendance. And so let's hopefully hear something from the participants. I haven't done a general mute on this. All of you, I think, have muted yourselves and are not showing your faces, but you're very welcome to do so. I've promoted everybody to panelists, so you should be able to participate if you want to, and we'd be delighted to hear from you. I think there is some kind of hand system, but you can send things by chats. I see there's something from, we've got a couple of things on chat. Look like they're both for Mark to answer. I don't know if you care to deal with those, Mark, before you get started.
Sure, I'm happy to speak to Anna's question, but I think Nabilia's might be for you, Doran.
Yeah, okay.
So Anna has asked, as far as we're aware, is there an emerging trend for PSA-based disputes to be submitted to the Astana International Financial Centre? And certainly from my experience, I'd be very interested to hear what anyone else has to say, but I think it is too soon to see that trend. It's a very recent centre, and I don't think there's been any early adopters, although I suspect Kazakhstan will be putting it in to its PSAs as they go forward. But beyond that, certainly if we look at the example of, say, the DIFC, so the Dubai International Financial Centre equivalent in the Middle East, it took probably 3 or 4 years before we started seeing major contracts being referred to the DIFC courts or arbitration, as people wanted to have some certainty around that before they opted in. But certainly I think you'll be seeing Kazakhstan PSAs featuring it going forwards. but increasingly, as people are looking for neutral venues within the region, I think we will see a push towards that, and particularly where we have regional law JOAs or services contracts, I think that will be a strong contender.
Okay, well, I'll answer the other question about states suing the foreign contractors. I mean, this is not a state-state dispute. It should be a question of contract with the contractor, and the contract will provide for dispute resolution, either in court or by arbitration. It is, I have to say, in my experience, rare to find a contract with a foreign contractor that doesn't provide for arbitration, international arbitration, but it may be, there's certainly been a few with local subsidiaries of contractors, to my knowledge, in Russia, where they end up, could in theory at least go to the Russian courts or to Russian arbitration. So I think you have to look at your contract to see where that goes. And a win-win resolution is usually a settlement. And that takes some skill on the part of the advisors involved. Yeah. Can we hear from members of our public, as it were? All you have to do is you're welcome to hold up a hand if you can figure out how to do that, or just intervene. Just turn on your speaker and your microphone and ask the question. Everybody seems to be a bit shy. I had a question for you, Mark. You mentioned countries that have new laws and that are unfamiliar to working on this sort of thing. And I believe you have had experience in advising a Central Asian country on a dispute. What was it like in practice working with the officials of a country like that? Did you find them easy to deal with, or did you really have to educate them in order to enable them to be constructive?
I mean, I think it does vary remarkably depending on who you're talking with. And it's always dangerous to make generalizations, but I think there are generational differences in terms of individuals who've come in to the ministries in more recent years, who come with a great deal of energy and approach, and a realization that this is new and that there's policies to be set and decisions to be made. And there are inevitably certain old guard members who are constantly surprised that the law may not still be what they were used to, and that the dynamic of power has changed. And I'm very unfamiliar with the concept that the actions of a state might have consequences. And I think this exposure to, particularly to investment treaties, and this horrific discovery that if you breach your contract, you may not just have a local law problem, but an international law problem, I think has taken some getting used to, and discovering that investment treaties have bite, which of course is the whole reason for having them in the first place, has been surprising. But I mean, I've certainly found it a great pleasure to work with the states I've been involved with, and I think there's a great deal of willingness to engage and resolve these difficulties. I think there's just been some eye-opening along the line as to how the system works and how people come with different expectations.
I've actually got something for you, Paul. You mentioned relational contracts, and what you didn't mention was the phrase good faith. As it happens, just before we started up, I tuned into another webinar which is going on at the same time about the concept of good faith, and I wonder, to what extent are these contracts that you deal with, are they really relational contracts, and do you see them as that, or are people just taking a very hard view on the exact wording? How does that work?
Well, I think the English law doesn't move very often. And I think when it does move, it moves slowly. the question of relational contracts tended to be rather an academic pursuit. This is the idea that most of contractual theory is based on spot transactions of buying, selling, and that's it. Nowadays, if you were to go on to an internet-based scheme, Amazon, click the button, you've made your deal. Relational contracts tend to be longer term, and performance depends on the cooperation of the parties. And there's more to it than just yes and no. Long-term gas agreements are extreme examples. If you think how difficult it is to make any delivery, or particularly if you're in the LNG business, to deliver a cargo relies on many third parties, and the parties have to want to do it together. So rather academic until 2013, when one case in the English High Court did find an implication of an obligation of good faith within a contract, assisted by categorizing it as a relational agreement. So traditionally, English law doesn't have a duty of good faith, very different from many laws which will have, often under a code, a duty of good faith in the performance and implementation of agreements. Some laws have an obligation of good faith in the making of agreements, which if you're a common lawyer is rather a spooky idea, but certainly Israel is one of those countries. So under English law, there has been a move in recent times to suggest that the interpretation and enforcement of agreements, which can be categorized as relational, and it's not just being long-term, it does require more than that, may give rise to judicial flexibility or judicial tolerance in assessing the rights and obligations and liabilities of the parties. And this isn't something which goes into a general duty of good faith in English law. It's consistent with the freedom of contract, and the interpretation of the agreement the parties have made is such that, properly interpreted, the parties have entered into an agreement which does have some regard to the position of the other party, and it's not necessarily just an adversarial matter, because over time interests change and things change. And if you look at certainly the examples of Russian gas into Europe, many of those price reopener arbitrations, some of the largest arbitrations ever to take place, had their basis in a change of circumstances and one party being out of the money because of market change.
And the follow-on question, do you see a lot of difference between the kinds of disputes that arise or the way they're treated between pipeline gas and LNG?
I think there is, and it was interesting as Mark was mentioning that we're in an industry which has largely been related mainly to oil until recent times. Oil disputes really quite different from gas disputes traditionally, but also within the pipeline disputes, because of the fixed nature of